first of all, let's just have a quick look at the agenda for the day. I'm not going to dwell on each of these points in turn, just to put it on the screen, more as a route map, if you like. The agenda is to help you work out, as we go through the topic, where we actually are, where we've got to on our journey through dividends and distributions. So those are the issues that I'm going to cover. So shall we start off by beginning at the beginning with where to find the law in relation to dividends and distributions? And as with so many areas, we're looking at a combination of sources for dividend and distribution law. We're looking, first of all, at long-standing common law established by the courts, and the basic principle that comes out of the courts in relation to dividends and distributions is that no distribution may be made out of capital by a company, even if the company's articles authorise such a payment. So that's a précis, if you like, of the common law position. That is supplemented or superseded, whichever term you want to use, by Part 23 these days of the Companies Act 2006, which I refer to on these slides as CA 2006. And you're looking at a fairly substantial number of sections. You're looking at sections 829 to 853. So that's what we're looking at, the combination of common law and statutory law. Specifically, some of the provisions which I think lawyers need to be on top of, even though maybe it's the accountants who are front of house in respect to these rules, is that the lawfulness of the distribution in the last annual statutory accounts has to be judged by reference to items specifically mentioned in the Act. There's the relevant section numbers for you. And what those sections say is that the last statutory annual accounts must be properly prepared, and there's a meaning for that. And that means prepared subject only to matters that are not material by reference to items mentioned in section 836 in determining whether the distribution would convene Part 23. So the accounts have got to cover certain things. If the company's accounts have been audited, unless the directors are exempt and the directors have taken advantage of the exemption, if they have to be audited, then there must be an auditor's, the directors must consider the auditor's report as well. And if that is a qualified auditor's report, there are additional requirements. The directors must get a separate statement to be circulated to members if the company's private. And if it's a public company, it actually has to present them to the members in a general meeting, a shareholders meeting. And there are rules about that statement. So often background for the legal advisors involved in a distribution, accountants are front of house, but important to be aware of what these underlying rules are, and those are they.